Jurister kan være festlige, og som Patrick og Gustav allerede har vært inne på, juss spiller en viktig rolle, internasjonal juss, og Norge er, enten vi tror det eller ei, knyttet til det europeiske fellesskapet med en del avtalebånd. Så Karl Baudenbacher vil jetzt erklære og describe for us what we can do and what we can't do in this country that chooses to be different, og kaller seg annerledes landet. Okay?
You look at the names of the judges, because it makes a huge difference whether Judge A or Judge B has been sitting in a case. And what is virtually always overlooked is the preeminent role of the Advocates General at the Court of Justice. And in particular in gambling law, you know, the outcome depended in two crucial cases on who was the Advocate General. We don't know exactly who appoints or names the Advocate General in a case. All this part of this opaque French legal system. I'm Swiss. I think I know what I'm talking about when I speak about the French. And then something else which you have to take into account is who has been the judge rapporteur, the one who has written the judgment, the first voting judge in Norway. Because given their caseload, you know, most of the judges do not really look at the cases. They just leave that to the judge rapporteur. And the judge rapporteur may be an expert in the field, may also be a former bureaucrat or a former politician who doesn't have much of a clue. And then the judge rapporteur leaves that to a legal secretary. So at the end of the day, and in particular in gambling law, the outcome of a case may be in the hands of a legal secretary, which may be a good lawyer, but is not really legitimate to prepare this ruling. Then, point number 4, the crucial thing in gambling law is a proportionality test. You know, if you want to restrict a fundamental freedom under European law, whether EU or EEA is the same, you can only do it if the restriction is proportionate. That means the country in question must pursue a legitimate aim, and then the measure must be suitable to reach this aim. It must be consistent with other measures taken, and it must be necessary to reach the aim. This is a figure which comes from German law and has then entered European Union law, but in particular in Norway, you may know that, you know, the government is always pleading a wrong proportionality test. They say it's enough that the measure is plausible, that according to our Nordic understanding, you know, we can prohibit this and we can prohibit that. And the judges often have difficulties, you know, to stick to the true proportionality test. Then point number 5, also crucial, what is left to the national court? You may get a very liberal judgment in Luxembourg from the ECJ or from the EFTA court, but then the national court in Norway or in Sweden or wherever, you know, has to give the final ruling in preliminary ruling cases, and what they do with the case is probably often another matter. And my last point will be, what are the EFTA court's contributions? Now, what is the EEA agreement? It's the most comprehensive integration treaty ever concluded by the European Union, in force since 1st of January 1994, with 2 pillars, an EU pillar and an EFTA pillar. And the quintessence of the EEA agreement is the fact that the EFTA states have their own surveillance authority and their own court of law. This was unexpected, that they were able to negotiate this, and yet they succeeded. And a lot depends on these 2 institutions. The main part of the EEA agreement has been implemented into Norwegian law, and even if Norway is a dualist country, this main part takes precedence over conflicting Norwegian law. Now, the EEA agreement is about freedoms, 4 fundamental freedoms. It's about market. It's about those who create wealth, not about those who deplete wealth. And yet in Norway there's too much emphasis on the state, too much emphasis on restrictions and not on freedoms. and then a very special, well, you cannot call it legal, it's an illegal figure has been developed that is called room for maneuver. Room for maneuver is unlawful as a concept, and yet it is all over the place. And I would say it's nothing else than Norway first. This is Trumpism at its best. Then, very important for Norwegians is the role of the state attorney here, regeringsadvokat. There we have seen over the years and decades a revolving door between the Oslo law faculty and the office of the regeringsadvokat, people moving forth and back. That means the regeringsadvokat has not only influenced, what is done in the courts, but has also influenced the education of the law students. And as far as I can see, there's a whole generation which has been misled by the teachings of the regeringsadvokat in this country. If proof was needed, it would be there in form of the NAV scandal. However, the EA agreement has created a market, and this has been recognized by the EFTA court in a case where I was judge rapporteur, De Vecchi. It is clear that those, who create wealth are producers, workers, consumers, traders, investors, also offerers of gambling services. They create wealth. They pay taxes, not those who deplete the wealth. Okay, now two-point case law. I said that the ECJ has unfortunately performed a slalom in this area of the law. It started in the Schindler case in 1994. Schindler case was about a UK ban on lotteries, and two German brothers with the name of Schindler were affected and brought an action, and it ended up in the ECJ. The Commission, the European Commission, was very cautious in this first case and said, we cannot have a total ban of gambling activities, in this case lotteries. It would be incompatible with the freedom to provide services. There must be less restrictive means. That means the Commission wanted to carry out a strict proportionality test. But the ECJ was very insecure in this first case, and they said even a complete ban on lotteries may be justified by overriding requirements in the general interest. The case was decided by the big plenum of the ECJ at the time. That's another point you have to look at, whether a case is decided by a three-judges panel or by the Grand Chamber today, at the time by the big plenum. So what they did here, they applied a light proportionality test, and at the end of the day, it was enough, that the whole thing seemed to be plausible. It was a margin of appreciation test. The same was done then in a Finnish case, Leere. Finland had a state monopoly with regard to the right to operate gaming machines. It was not a ban, but it was a monopoly. Nevertheless, this Schindler case law was extended to the gaming machines. This time the small plenum sat, not 11 but 9 judges, but still the case was deemed to be politically sensitive, so they didn't give it to a simple chamber. The same light proportionality test as in Schindler. The whole thing then changed in the Gambelli case. There was a whole series of Italian cases. In Italy, there was always the suspicion that the mafia was involved in gambling, obviously. But yet the Italian state pursued a policy of expanding gambling and betting with the aim of generating revenue for the state purse. And in this case, we had a very liberal, market-oriented Advocate General, good friend of Doris and mine, who passed away last year. That was Mr. Alber. Siegbert Alber, market-oriented, he said, this is dishonest. If the state monopoly encourages consumers to participate in gambling to generate revenue for the public purse. This cannot be justified based on public social order. And the ECJ followed Mr. Albert here, was the small plenum, 9, much stricter approach to proportionality, a test which later was called hypocrisy test. That means Lehrer and Schindler were overruled, but again, this weakness of the ECJ, the overruling did not take place officially. The ECJ did not say, we hereby overrule this old case law. They just changed it and left everything to the interpretation by the lawyers. This is not good for legal certainty. This is the ECJ's biggest problem in my view, and that's one of the reasons why a lot of British lawyers were in favor of Brexit. Because the ECJ is operating in this French tradition, and British tradition is totally disregarded. And when I say British tradition, I mean common law in general. This includes the United States, this includes Australia, New Zealand, South Africa, and so on. So you can only restrict betting services, the ECJ said in Gambelli, if this is done in a consistent and systematic manner, and member states which encourage consumers to participate in gambling cannot rely on public policy concerns, because then they are hypocrites. And this was confirmed in a subsequent ruling, Placanica, landmark case. Again, the Italian legal situation. Mr. Placanica was an agent of a UK betting operator, Stanley International. ECJ, again, applied a strict proportionality test. Necessity must be proven and no hypocrisy. Yet there was another weakness of the judgment, that they left the final decision to the National Court without clearly telling the National Court on how to resolve the case. This is a risky business. We made this experience ourselves in Ladbrokes, where we had felt that we were absolutely clear, and yet the Oslo City Court ruled in favor of the state. With this, I come to the EFTA Court's 2 landmark cases in which I was president and judge rapporteur. Well, I had the freedom to assign the case to myself, and that I did. And unlike most EFTA Court judges, I have always been market-oriented, because the EEA agreement is a market agreement. In June 2003, the Storting passed a law granting Norsk Tipping a statutory monopoly for the operation of gaming machines. 130 private operators were removed from the market, and the law was challenged on 2 fronts. On the one hand, private operators sued before the Norwegian courts. They won before the Oslo City Court, but lost before Borgarting. Well, it's difficult to win a case against the state in the Borgarting Court of Appeal, if I see it correctly. And the Supreme Court rejected a request to refer the case to the EFTA Court, which was actually not the right thing to do, because it was the first big gambling case in the history of the whole EEA, the first direct action of the EFTA Surveillance Authority against. I'm talking about the reference case. ESA then brought an infringement action, yes, against Norway before the EFTA Court, and the Supreme Court stayed the proceedings. Now, the crucial element of the case is that the monopoly had not yet entered into force. So you may say that ESA sued too early. In any case, we had to take this into account. We applied a strict proportionality test, consistency and systematicity, and we said this must also include effective control of the monopoly's activities once the legislation has entered into force. But we also said it's reasonable to assume that if the state has nationalized this activity, it will control the actions of the state monopoly. And we said as long as the state monopoly is subject to effective control, we would tend to think that it would, be better than if commercial operators did this. I cannot reveal how we voted in this case, but I sat with two Nordic colleagues. And on the 14th of March 2007, the EFTA court dismissed ESA's application, but the judgment was a as long as judgment. That's a technique which has been developed by the German Constitutional Court and has been taken over by the European Court of Human Rights. We said as long as the state effectively controls Nord Stream, it is lawful. But the conclusion is quite clear. If they wouldn't control it, then this presumption of lawfulness would be gone. That means it was no carte blanche for running a state-owned gambling business. We applied a very strict proportionality test. And yet, the Supreme Court then in his own judgment claimed, I mean, it was outrageous. You have it here. Yes, on the right side in Norwegian. My Norwegian is not good enough, so I will say it in English. The Supreme Court said, well, that's a wonderful proportionality test. That's what we are used to in Norway, a moderate proportionality test. This is about political issues, and then we leave it essentially to the legislator. This is in good harmony with the Norwegian tradition of judicial review of assessments of a distinct political nature. This ruling had to be given because one private operator had refused to give in. I think this was Mr. Ottar Dalseth at the time. And with this, the whole thing was done. And since this judgment was rendered by the Supreme Court, most Norwegian judges seem to believe that this is the clearest thing you could have. Nothing has changed since then, and you can plead whatever you want to plead. If you represent a private operator, it's an uphill fight. It's an uphill fight. Now, we never made such a statement. On the contrary. And since the Supreme Court, said that a light proportionality test is good enough, they also disregarded the as long as element in this case. It was clearly a political judgment. I'm reminded of the classical book by Josef Esser, a famous German professor who wrote about Vorverständnis und Methodenwahl in der Rechtsfindung. That means pre-understanding and choice of method in finding the law. Pre-understanding is the same as attitude. That is like, the Republican justices on the U.S. Supreme Court have a certain attitude, and the liberal judges have another attitude. Second case was then Ladbrokes, the world's largest bookmaker and gaming company, applied for a license to do business in Norway, and the state denied permission. This case was not a direct action. It was a reference from the Oslo City Court. And unlike in gaming machines, the state monopolies here were already in operation. We stuck to our case law from gaming machines, were even more outspoken in this case, and said must be consistent and systematic in order to be proportionate. A policy would be inconsistent if the state took, facilitated, or tolerated other measures that would run counter to the objectives pursued. This concerns in particular marketing expenses and the development of new games. And then we applied the classical proportionality test, suitability, consistency, and necessity. And we set the level of protection chosen by the Norwegian authorities is decisive. And if the Norwegian authorities let the monopoly, do whatever it wants to do, then the monopoly is not necessary. Then you must leave it to the market. Now, importantly, in this case, the state pleaded a light proportionality test. The state said that judicial review of national restrictions is limited. The courts ought to assess the necessity of the measures only where there are reasons to believe that the rules are in fact discriminatory or protectionist. We rejected this. We explicitly rejected this, and yet I think the state always pleads that in all gambling cases until today. Not only in gambling cases, in virtually every case which is about restricting fundamental freedoms, the regeringsadvocaat habitually pleads a light proportionality test, which is wrong. Now, another point is that the Norwegian courts have confused the level of protection with the proportionality test. That's not the same. You have to distinguish that. And as stated in Gambelli, Plakanica, gaming machines and Ladbrokes, a high level of protection does not mean that the measures are sheltered from judicial review as to their proportionality. I may quote here the Norwegian professor Tor Inge Harbo, who said, this must be distinguished. This has nothing to do with each other. Now, we had felt that after, the Supreme Court in gaming machines had ruled in favor of the state, at least in Ladbrokes, the state would have to lose. And yet, the Oslo City Court, under the instruction of the regeringsadvokaten, came up with a ruling in favor of the state. As usual, the regeringsadvocaat pleaded a distorted proportionality test. It was a pure misimplementation of our judgment. And then they came with this channeling argument. And my Norwegian is not good, but I understood that in the previous session there was a lot of talk about channeling. Frankly, I think it's bogus. I think that the whole idea of channeling desires to gamble from one game to the other is bogus. This is based on an idea of mankind which has, in my view, nothing to do with reality. But unfortunately, there's an argument which was brought by the ECJ early on and which is being pleaded all the time. Now, Ladbrokes appealed to Borgarting, and then, the ECJ went on with its slalom, and they deviated from Plakanica in the Liga Portuguesa case. It is what was a fall from grace, and in criminal law you would call it a relapse, rückfall, a rückfall. BWin, a private operator established in another EC member state with servers in Gibraltar and Austria, offered games of chance in Portugal over the internet. And the fact that this was done over the internet was used by the ECJ to make this relapse. That we had a restriction was clear, and the ECJ relied on Lere and another previous judgment, and at the end of the day, they bought into the whole argumentation of the Portuguese government. I think these slides can be made available to the people here, so I don't have to go through all of them. They just bought literally every argument. And in particular, the so-called internet defense. They said more or less, the internet is devil's work. It's way too dangerous, because then the Portuguese authorities cannot control what is happening abroad, because this comes from abroad. It was the first case where we had games offered from abroad, as the ECJ said, operators having their seat outside the national territory and using the internet. Well, if you look at, how old the ECJ judges were at the time and what their technical abilities probably were, I don't know exactly, but I could imagine that many of them had not much of a clue about how the internet worked. So the ECJ ruled that due to the lack of direct contact between consumer and operator, games of chance accessible via the internet involve different and more substantial risks of fraud. And with this, they threw out the baby with the bathwater. All this was highly speculative and theoretical. Interestingly, they followed here the French Advocate General. That was Mr. Yves Bott, who died a couple of years ago, a mercantilist, a well-known mercantilist, a personal friend of President Sarkozy at the time. And he had influence on the ECJ, and the judge rapporteur was Mr. Schiemann from the UK, and Schiemann was not a born Brit, he was a born German, and he always wanted to show how faithful he was to the ECJ. And years after this, I gave a talk in Cardiff, and a commission man came to me and said, this was the most outrageous case I've ever been in, because the operator of the state monopoly was a Santa Casa da Misericordia, a Portuguese lay order, Catholic lay order, which was organizing this football betting, for good causes. Well, like here, not Catholic, but still for good causes. And they sent an agent in a monk's habit to the ECJ. This is the Order of the Holy Trinity. And in order to convince the ECJ, one of their pleaders came in a monk's habit. Now, the gentleman on the next slide is not a monk. Minister Trond Giske was super happy about Liga Portuguesa and said this is an important victory for Norway and the other member states within the EA who wish to protect their citizens against the negative aspects of gambling. He almost went crazy with joy, understandably. It was a very positive thing for him. He said this is a very powerful tool when we come to Borgarting, and the trial was scheduled in Borgarting for the 15th of September 2009, and on the 10th of September 2009, Ladbrokes withdrew its appeal. They had obviously come to the conclusion that they had no chance, and they were most probably right. Now, after this, the ECJ came to the next gate in its slalom. 1 year to the day after Liga Portuguesa, they decided the Markus Stoß case, a case originating from Germany. And in Markus Stoß, they more or less came back to the previous case law, even extended this previous case law. The hypocrisy test was applied, was extended. And interestingly here, we had a market-oriented Advocate General. My good friend Paolo Mengozzi, an Italian, who was an important partner in dialogue for the EFTA court also, he said, if you market your games as a state operator heavily, you are hypocrites. If you then invoke the dangers of gambling, the ECJ applied a very strict proportionality test, and this clarified the situation in the European Union, but not only in the European Union, also in the EA. It's relevant for the EA under the homogeneity rules of the EA agreement, and yet, as far as I can see, Norwegian courts don't really recognize this. I think this was confirmed in later case law. Now, important, a word on the general principles and fundamental rights. They are often overlooked by positivists. And with general principles, I mean homogeneity, reciprocity, and loyalty. Loyalty is the same as good faith, or also called in European law sincere cooperation. Loyalty doesn't exist in the pleadings of the Norwegian government, has never been mentioned. I sometimes asked the agents in Luxembourg, why don't you plead loyalty? No, they did not do it. Instead of loyalty, they have room for maneuver. And that, in my view, is unlawful. Also because the enforcement of the law in the EFTA pillar is to a greater extent in the hands of national courts than in the EU pillar. And I have two citations here, one by University of Bergen, Professor Christian Frankling, who said, the principle of loyalty in EEA law is even more important than in EU law. And the first president of the EFTA Surveillance Authority, Knut Almestad, has written, good faith, which is the same as loyalty, is the keystone which supports the EEA edifice, without which the construction might crumble. And as far as fundamental rights are concerned, I just point to Article 16 of the EU Charter of Fundamental Rights, the right to conduct a business. This is rarely pleaded, although the EFTA Court has, a couple of years ago, recognized that this right to conduct business is relevant in EEA law, even if it is not part of the written EEA law. It was also a judgment in which I was judge rapporteur. Now, we see that it has become very difficult to win in a Norwegian court, but then there is the EFTA Surveillance Authority. What about the EFTA Surveillance Authority? They have made a policy change a couple of years ago, which in my view cannot be explained. First of all, the Commission made a policy change, the European Commission. And I just want to show you this interview which Commissioner McCreevy gave in 2006. That was the year of the gaming machines case. He gave an interview in the German magazine Der Spiegel, and Der Spiegel said to him, and McCreevy was a well-known gambler, he would fly to Ireland almost every weekend to bet on horses. He did that openly. The Spiegel said to him, there is the idea that state-owned Thank you. Providers are less profit-oriented than private ones and more oriented towards the common good. That's what the Spiegel said. And McCreevy said, do you believe that? And the Spiegel asked, don't you? And McCreevy said, I don't believe a word of it. And he said, all we have to make sure is that there is no hypocrisy. You know, that they do not encourage, the state doesn't encourage gambling in order to fill its own pockets. No double standards, no double standards. And then, after a few years, in 2017, the Commission said, we don't bring actions anymore against member states because of gambling restrictions. They closed all infringement procedures and all complaints without result, and said this can be done in national courts. You can sue there, that's good enough. And ESA, you know, had got a black eye in the gaming machines case. They resented that a lot because it was their first big defeat. And ESA had always had a policy of bringing only waterproof cases. And at the end of the year, they would write in their annual report, ESA has a quota of victory of 100%. Now, this one was not so good for them. And then, at the end of the day, they said, we follow the commission, and also said, we will not enforce the fundamental freedoms anymore in the area of gambling. This was done by what I would call the weakest college of all time. That is a problem of ESA. There are only 3, and they change composition very frequently. And you may have a strong college, as we had when Almestad was there, as we had when Sven Svedman was there. But then in between, you may have a college which is, well, not very helpful for private operators. And that ESA closed the cases, although it doesn't work in the national courts at all, amounts to comparing apples and oranges. Because in a German court, you may have a chance, whereas in a Norwegian court, it's very difficult. Private enforcement doesn't work in the EFTA pillar, and that means that ESA's policy amounts to depriving private operators of their rights in this field. I know that not everybody in ESA was happy about this. The legal director was very unhappy, but at the end of the day, they just decided it. ESA's fundamental problem is that with 3 college members, they are not necessarily weak, but they are vulnerable, as Sven Svedman said. If you are only 3, you are vulnerable. If one doesn't work, you know, or is lazy, or I don't know what, you are in trouble. The college members are, as a rule, former national bureaucrats who often return to government service after the time in Brussels. So some of them may have a tendency not to step on the toes of their government. And it has been shown that the embassy in Rome was a prize for good behavior by ESA presidents from Norway. Rome must be a fabulous place for an ambassador, not much going on, and still a wonderful city. And there have been now, due to this weakness of only 3 college members, phases when ESA was rather strong and phases when ESA was rather weak. It all depends on who is sitting on the college. And here I have to say, unlike when it comes to the Commission, there is zero transparency when these ESA college members are chosen. They are picked behind closed doors, and there is no open debate or something like that, no interviews. You just read in the newspaper, this and this gentleman or lady has been chosen as college member. And in addition to that, and that's not so good for you as Norwegian private operators, the presidency seems to be a Norwegian patrimony. It's always in Norwegian hands. In the almost 30 years of the existence of the EEA agreement, an Icelander has been president of the EFTA Surveillance Authority for 17 months only, and otherwise it was always a Norwegian. Now, the chances before the Norwegian courts are obviously limited. There have been recent cases in which Norwegian courts have tended to stick to the wrong interpretation of gaming machines by the Supreme Court and Ladbrokes by the Oslo City Court. The Markus Stoß case is being disregarded. Regeringsadvokaten tells the judges to do so. Also, the fact that the EFTA Court has clearly rejected a light proportionality test in Ladbrokes is disregarded. I just may remind you that both under EU and EEA law, attorneys are, I quote, collaborators in the administration of justice. That's what the ECJ held in the Axo Nobel case. In a different context, but it goes beyond these cases. And to my knowledge, the same concept exists in Norwegian law, that an attorney is a collaborator of justice. and der Regierungsadvokat must a fortiori be deemed to be bound by loyalty. Then what about asking a Norwegian court to make a reference to the EFTA court? I think that many of the national judges are not willing to do that because they claim that everything is clear. And if they would do it, at least in the last couple of years, it would have been quite a gambling case, so to say, because also the EFTA court is vulnerable with 3 judges, and the Rheinzone court, the Rheinzone is my successor, has been very government-friendly in the Henry Christoffersen case, the famous skier, for instance, in public procurement cases, Fosen, and in certain NAV judgments where they just came to the help of the Norwegian government in a rather embarrassing way. And Mr. Rheinzone is working for his government on a permanent basis while presiding over the EFTA court. There is a list of payments on the internet where it is shown how much he makes every year from the government, and nobody says a word about it because he's so friendly to the governments. This is not a problem for ESA. There has been a complaint lodged against Rheinzone because of that. ESA said, we cannot interfere with the independence of the EFTA court. I mean, it was like a carnival scene. The same goes with regard to the lack of a Article 255 panel in the EFTA pillar in the EU. We had for many, many years an independent panel which would assess every candidate for judgeship proposed by a national government. But the Norwegian government has refused to have such a panel in the EFTA pillar. And again, ESA saw no problem in this. We have in the last 2 years seen an open attempt from the Norwegian government to pack the EFTA court with a well-known government-friendly judge. The EFTA court has consisted of 2 regular judges for more than 1 year, and the third one only on the payroll for a whole year. And a new Norwegian judge will now be sworn in at the end of June, on the 30th of June of this year. And so we will see whether this is a judge who has probably a certain understanding for fundamental freedoms and for private market operators. So my conclusion is that you are on the right track here. You should rely on new Norwegian legislation. You should rely on the Storting. Probably after the next election, I cannot say anything on that. Double standard is the basis of the case law of the Norwegian courts in the gambling field. And we have seen that there is also double standard by other actors. Chairman has recently written, I saw it on LinkedIn and also commented on it. And ESA is totally inactive. ESA doesn't do anything in the gambling field. The Norwegian courts rule the way they do. So at the end of the day, a legislative solution like in Denmark, Sweden and Finland should probably be decided by the Storting. And here it's obviously important, to focus on comparative law. It's obviously important to focus on economic analysis. A new model must be both fair and efficient, fair towards individuals and efficient from a point of view of scarce resources. So at the end of the day, probably a licensing system like in Denmark, Sweden, and in the future in Finland would be the appropriate solution. I thank you very much for your attention.